All right, I think it's 12:30. We're going to get started. I think everyone who's signed on to the website is currently has logged in on their phones. So I think we're set to go. Thank you all for joining us on this wonderful day, October 4th. You are going to be listening to ESOP Legal Pitfalls. My name is Tabitha Croscut. I'm an attorney with Steiker, Fischer, Edwards, and Greenapple. We are a law firm with 7 ESOP attorneys focusing primarily on ESOPs and all of their needs. Our attorneys are located in Philadelphia, Rhode Island, Vermont, and New Jersey offices. And we also, just as a helper in describing the relationship with SES Advisors, which is where you came across this webcast, SES Advisors is a sister company to our law firm and is an ESOP consulting firm providing ESOP administration and transactional analysis as well as other consulting services, and extends additional offices in New York, Virginia, Indiana, Illinois, and Texas. So we have a great presence across the U.S. here. And it is my task today to give you some insight, some education, hopefully not scare you. That's not my intention, but in fact to give you some tools that you might be able to use yourself without paying legal fees to avoid some of these pitfalls. Before we get started, just a couple of administrative tasks. You can certainly type in the chat feature on, I believe, the left bottom corner of your screen if you have questions. Sort of like raising your hand, I guess, and I will do my best to keep track of that and answer questions, and feel free to do that as we go along. You can also email me after the webcast today, and I will also try to leave 10 to 15 minutes at the end of the webcast and unmute the line at that time to see if we can answer some questions then. The webcast is being recorded. So if you have a desire to listen again, feel free, probably within 24 or 48 hours, the webcast will be up at the www.sesadvisors.com website. I think that will do it. I think I mentioned this is a recorded webcast, so any questions at the end will be on the recording, and we will jump right in here. So the intent here is to cover, for those who have either recently adopted an ESOP, those who have been an ESOP company for years, or even for those companies who are looking to adopt and implement an ESOP as a transition strategy. I'm hoping that this webcast will provide each of those groups of people with some useful information on how you might identify and hopefully avoid common red flags in ESOP transaction documentation and some plan operations. This certainly in an hour is not going to be a very in-depth discussion, but it will hit on some of the more prevalent pitfalls that I've seen. And what I hope to cover is we're going to take this in categories, looking at initial design and qualification requirements for ESOPs, then going into ongoing qualification compliance, leading into transactional requirements, and then rounding it out with some common sources that cause ESOP companies to fall into the pitfalls and some prevention strategies or suggestions. So starting with initial design and qualification requirements, obviously this is going to be information that's more useful for those ESOP companies who are looking at right now adopting an ESOP, and a little less insightful for those who have already adopted their ESOP. But nonetheless, hopefully you've gotten the right advice and you've done all of this correct anyways. So the place to start here is just to remember that ESOPs, as employee stock ownership plans, are qualified retirement plans. What that means is just like a 401k plan, a profit sharing plan, a money purchase plan, there are specific requirements under Internal Revenue Code Section 401A, of which all of those types of plans as qualified retirement plans need to meet the requirements. For ESOPs, there are additional requirements in Section 409 of the Internal Revenue Code. And what those sections provide for are things like your vesting schedule, the 3-year cliff, the 6-year graded, the requirements as to how you credit service, requirements on minimum eligibility and entry dates for your participants, employees. Those are grouped mostly in the 401A area of the Internal Revenue Code, and thus the similar requirements in vesting and eligibility and entry date apply to your ESOP as would apply to a 401K or profit sharing plan. The special requirements for ESOPs found in Section 409 of the Internal Revenue Code get you into the distribution form and timing rules, and of course the put option that is specific to ESOPs and stock bonus plans as well. So just to begin the conversation of, remember that there is this whole structure of rules that the ESOP must comply with, and the reason for that is to maintain the qualification of the plan, which results in the tax advantage nature of the ESOP, including the tax deductibility of contributions to the plan by the company, the deferral of tax by the participants who receive the allocations within the plan. So all of your tax advantages are derived based on the qualification of the plan. So it is essential to make sure that the qualification of the plan is maintained, or you really fail to meet the goals in establishing the ESOP as a retirement plan and as a succession strategy. The key in initial plan design is to realize that there are no two companies that are looking for the same design. I can't take a plan that I did for company A, take it off the shelf, copy and paste it, and apply it to company B. Does that happen? Yeah, certainly. You know, there are companies out there who are getting the boxed plan, the form plan. But in general, each company needs to consider, what is your plan trying to, what are you trying to do with the ESOP? Is it purely a succession strategy and you don't really want to think about it anymore? Or are you really trying to use this plan to retain, reward, incentivize, increase profitability? And if there are other objectives, then you really do need to take some time at the beginning before the plan is actually adopted and executed by the company. Take some time and walk through the provisions. The legal pitfalls here is, for those companies who have already adopted the plan, they may have already come across this. But for new plans who are looking at the appropriate provisions, the concern is that there are a lot of provisions that once you have them in the plan, that is, once the plan has been designed, drafted, and executed, once the close of the plan year occurs, which is typically, not always, but typically January through December, so come the next January, I've seen many an instance in which an ESOP company is doing their annual administration, you know, January through April, May, and they come across something that is interpreted in a way in the plan that they dislike. They just don't want it applied that way. For instance, maybe an entry date. They didn't expect someone to get into the plan when they did, but now the plan year has closed and we can't retroactively go back and change that entry date. So it's important as you start looking at the provisions of the plan to think about all of the little details of the particularly the provisions that you can tweak to your needs or your liking. Many provisions can't be changed during the current plan year. You have to be careful, because even if you're not beyond the plan year, but you're in the current plan year and you're looking to change something, once benefits have accrued, and that is generally once the participant has met the requirements to get an accrual of a benefit in the plan, you can't change the rules on them with respect to that accrual. You can change it going forward, but you can't change that particular accrual of benefit. So that creates a headache for some companies. The changes after the first plan year might make the administration more complicated. For instance, in a plan where they dislike the entry date, they figure it out after the completion of the first plan year. You know, maybe now you're applying 2 different entry dates because you're changing it going forward. More of a hassle would be a plan in which they've adopted maybe a 6-year graded schedule or even a 3-year cliff and decide after 3, 4 years in that they don't like that vesting schedule, that perhaps it's accelerating the repurchase requirements, what have you, and they want to change the vesting. But the vesting schedule will only, the change of the vesting schedule in year 4 or 5, what have you, would only apply to new accrual of benefit under the plan. So that would result in administration of the plan tracking 2 different vesting schedules for allocations pre and post that vesting change. Now, many plans do have that right now because of the change in the vesting rules with the Pension Protection Act. But typically, plans don't do that because they want to. So you have to be very cognizant, I think, when you're drafting the original plan to really walk through the plan, understand what is the effect of the different provisions that you at least have the ability to change. What effect does that have on your participant group, and does it meet your needs? And just a note at the end, again, if you wait until the end of the plan year, when you're actually going through the plan's administration for the previous year, it's often too late to change the rules. So it is essential to look at these things before you cross that bridge. So that's really in the initial plan design. It's an area that, most of the time when we're putting together the original plan document, most people are not really focused on the plan document at that point. They're more focused on the transaction for those who are doing both at the same time. And so the plan kind of gets put aside or just gets put together really quickly. But definitely warn people not to do that, to actually take a little bit of time and look at the details. So moving from the initial plan design, and just a brief warning on that one, going into the ongoing qualification and compliance, which is a much greater consequence for failure to maintain your ongoing compliance. So if you have a problem in the initial plan design, the result is that the company doesn't like it. They don't like that, Joe Smith got into the plan when he did, but you can live with it. It's not going to be the end of the world. Different story in terms of the ongoing qualification of the plan. So let's look at that. So the requirements for all qualified plans are subject to change, and you have to make sure that you're watching your plan, or at least someone is watching the plan, to update the plan for changes in maintaining the qualification. The failure to maintain the qualification, that is to have all the appropriate provisions in the plan, may result in plan disqualification, and the result of that, as I said in the beginning, is the loss of tax benefits. So no deduction for the company, no deferral of tax on participant benefits, and in some instances for the many, many S corporations that are now adopting ESOPs, that could mean the loss of the S election. So a significant consequence for just a failure to amend a plan. So ongoing compliance in terms of the qualification has a couple of categories. There's document compliance, which actually is the easiest. I mean, that is just a matter of someone looking at the document and making sure it has all the provisions it needs to meet the Section 401A and 409 of the code requirements. More complicated is the operational compliance. And what that really comes down to is making sure that what you're doing with your plan is reflected in the plan. So if you decide you want to call retirement age 65, look at the plan and make sure that the normal retirement age is age 65 and not 65 and 5 years of service. It's really just a matter of knowing your plan and making sure what your actions are is reflected by the plan. And the third category is the written records of actions taken, and that really goes to operational compliance. No plan can meet every single specific need out there. There are times when you have an ambiguous provision in the plan, and the administrator will need to interpret how that applies to a given situation. When that occurs, it's very important to have the plan administrator, or whoever the body or entity is that is in charge of the interpretation, create a written record of what the action, the decision on the action was, so that if the Department of Labor or the IRS comes in and audits the plan, there is an indication that the plan administrator made the decision, And that was the decision, that it just wasn't a willy-nilly type of thing. And the plan administrator generally has the discretion to make decisions. So it would be supported and no further question. So on the document compliance, that is category A, it is annoying, but it is the case that qualified plans are consistently being amended. The statute, the regulations are continuously being revised and amended, and so you'll see under legal updates, we had EGTRA in 01, we had the PFEA and AJCA in 2004, then there was the Pension Protection Act of 2006, one that is near and dear with the changes to the vesting schedule, forcing us to go from the 3-year cliff, and that should say 6-year graded, instead of the 5-year cliff and 7-year graded was the earlier schedule. So every plan had to be amended for that. Now there was and is an exception for ESOPs that had an outstanding exempt loan, but they still required those plans to be amended to reflect the appropriate vesting schedule post-repayment of that debt. So you still need to watch out for the PPA amendments. There was the HART amendment in 2008, WERA in 2008 again, another amendment, and then we had the final 415 regulations that were published in 2007, which changed the definition of compensation, and really that amendment snuck up on a lot of plans. So that's kind of the litany of some of the past. More of the recent required amendments, more recent is the amendment required for the required minimum distribution waiver that was permitted in 2009. If you have not heard from your advisors with respect to any possible amendment for the required minimum distribution in 2009, I would definitely reach out to them. You have until the end of the 2011 plan year, and you want to make sure that it really depends on how your plan is drafted as to whether you need an amendment or you can argue out of that amendment. I think we are typically advising that if you had anyone who fell into the required minimum distribution bucket, that is, you have people who are 70.5 and terminated is generally the definition, then you need to make some sort of an amendment to your plan to indicate how you operated in the 2009 plan year. So definitely look into that one. Hopefully, I know all of our clients should have received some correspondence on that. And so to our clients, I would say make sure you've executed any amendment that you need to by the end of 2011. The HART changes, adding military beneficiary death benefits, that came into play in 2010. You also had WERA actually requiring rollovers for non-spouse beneficiaries, or permitting the rollovers, but that language was required to be inserted into the document. And previously it had been a permissive provision. It is now required to be in the plan. And that amendment should have been made in 2010. And then again, the 415 regs, the definition of compensation was required in 2009. So those are some more recent. Now, why do we care about these statutory changes that required amendment to the plan? And this goes back to the document compliance. It goes back to making sure that your plan, your ESOP, meets the requirements of 401A, and those requirements extend to these changes. So it's not enough that the plan be operated in compliance with 401A and all of these amendments, but your plan itself actually has to reflect the language required by these statutory and regulatory changes. Determination letter submissions, I would expect that anyone who has an ESOP, at this point, you've all been through this process, hopefully. For those who are new to ESOPs, similar to 401K plans, except ESOPs are individually designed plans. Let me stop for a minute. And yes, someone caught my incorrect statement back here. That is correct on the vesting. It's 3-year cliff or 6-year graded. That was a typo. Absolutely correct. Thank you, Don. So going back to the determination letter process, there is now implemented a 5-year cycling of determination letters. And determination letters are important to ESOPs and all qualified plans because what they provide is really the IRS's blessing on your qualification. It's really saying you've adopted all of the amendments that you need to maintain the plan's qualification. Historically, that is before the implementation of the cycling process, plans could really decide whether, or companies could decide whether they wanted to submit their plans for a determination letter as they wanted to. It was not a requirement. It was just if you wanted to make sure that your plan was qualified, then you did it. And the reason to make an application was to make sure that if there were any amendments that needed to be made to the plan, you could take advantage of the remedial amendment period that resulted from submitting the plan to the IRS. Now, the rules have changed a little because in order to amend the plan within a remedial amendment period, you actually have to submit your ESOP on time that is within your cycle. So we have now new rules with these 5-year cycling periods, and it's dependent on the last digit of the plan sponsor's EIN. It is not the plan's EIN, but the plan sponsor's EIN. So what you do is figure out what your company or plan sponsor EIN number ends with. You figure out your cycle, and then as you look across, I'm going to get a little arrow here. As you look across, you see if my EIN ends in 1 or 6, I'm in cycle A. And the first cycle I had to file in was by January 31, 2007. If I file my plan with the IRS after that period, I will be outside of my cycle, which means, first of all, they put my application to the bottom of the list, and I do have a couple of those. And you also miss out on the remedial amendment period. So we're not sure what the IRS is going to do with that because there are some plans that just accidentally did not get in there on their cycle. And so I don't think the IRS has truly come up with a plan of action. And I think they have a large stack of those plans. So we have yet to see what happens. My advice would be to make sure that if you did not file during this first round of cycling, and you should have, I would suggest filing during the into the voluntary correction plan. And of course, that means you have to find something within the plan that needed to be amended. It usually isn't that hard, and you can argue that there's something that the IRS would not like and get it into VCP. And you'll find out in a second, in the next couple of slides, why the VCP is better than just letting the IRS find something outside of your remedial amendment period. Now, we successfully have finished the first round of the 5-year cycle, completing on January 31st of this year. I do have a little update here based on what the IRS has posted on their website. It's actually quite laughable that while we have finished with the cycle E's being submitted, the IRS has really only assigned to their agents. Cycle A's have all been assigned, and I think generally those plans have received their determination letters. Cycle B's have all been assigned, and I believe all of our clients have received their determination letters. The Cycle C's have only been assigned for those determination letter applications postmarked through March of 2008. So if you're a C, D, or an E, and you're a C that was postmarked post-March 2008, or a Cycle D or Cycle E determination letter, your application has not even been assigned to an agent yet. And we have already started working on and submitting the Cycle A's, whose period ends January 31, 2012. So we are right now in the second round of cycling, and the IRS hasn't even finished the first round. So it's going to get interesting. But that's the update in case anybody is wondering on the status of their determination letters. And again, the importance of this is to make sure that you've got the IRS's blessing on the qualification of your plan. That when you get an IRS or a Department of Labor audit, the first thing they ask for is a determination letter, because if you have a determination letter, they know your plan is qualified. They don't have to dig any deeper. So it is important. And now it's really more of a requirement and less of a permissible action. So the consequences of noncompliance. So what happens if, for instance, I did not amend my ESOP for the change in the vesting schedule as required by the Pension Protection Act of 2006? There are a couple of ways that it would be fixed. One is you could voluntarily submit it to the VCP program the IRS offers, or you could be more of an unlucky soul and actually file your application and or under audit get caught by the IRS failing to make that amendment. If you submit your application for a determination letter and you did not submit in through the voluntary correction program, but you just submit it with the failure present, and the IRS catches it during the determination letter process, they will put your plan over into Audit Cap. And the penalties are significantly different between the two programs. So under VCP, you can actually get under the $750 fee. There are certain amendments, failure to amend based on certain changes in the law. You could actually get an amendment submitted to this program for $375 right now. So if you catch the amendment, I think it's within a year of when it should have been adopted, then you get the lower fee. So these still look, you know, like a lot of money when you're talking about failure to just execute a document by a particular date. So, you know, it's a little ridiculous, but the alternative is if you don't submit this voluntarily, and if it's purely just a failure to amend, you just failed to execute the amendment providing for the vesting change, if that's the only failure, it's much better to do a VCP application, which is a really quick process, than to go into the Audit Cap. So in Audit Cap, that is, the IRS has caught you in audit, or you've done this during the determination letter, you did not file a VCP submission, the fees are significantly greater. And the penalties under the Audit Cap program are based on the whatever the change, the legislation was. So if you failed to make a change for EGTRA, this is your fee schedule. If you failed to make a change back for GUST, this is your fee schedule. And if you failed to make a change for both of them, we'll add these fees together. Now, if you compare these fees to what you would have paid had you just submitted under the VCP program, it's a huge difference. So that's why I say if you know that you have a failure to amend, don't just ignore it and submit it to the IRS. Make sure that you submit your VCP application along with the determination letter so that you can get the lower fees. And again, these schedules only apply for a failure to amend. It doesn't apply if you have other operational noncompliance. So just some quick horror stories. You know, I've worked with many of these, but two in particular, Company A, who ended up paying a penalty of $42,000. Unfortunately, the IRS started out, I think, on this one at $65,000. They had about 75 employees, and they were under audit. They had not submitted to the IRS for a determination letter, but under audit, the IRS came in. They asked for a copy of the EGTRA amendment timely adopted or a board resolution indicating the adoption of the amendment. The company was unable to produce either of those documents, and so based on that failure to amend, the penalty that the IRS assessed under Audit Cap was $42,000. Had we known that they failed to amend, we could have submitted them to VCP, and that probably would have been a $375 fee. The second was Company B, who had around 100 employees, and they failed to adopt the 409P language, which is the non-allocation required language for S corporations. And this actually was a plan that was submitted for a determination letter, and the IRS, during the determination letter process, figured out that the 409P language was not present, and so they kicked the plan over into Audit Cap, and after some negotiation, the IRS agreed to this $46,000 penalty, again under Audit Cap, and again another amendment that we could have made through the VCP program had we been given the opportunity. Now, some pitfalls to watch out for. Getting into certain amendments that need to be made to the plan based on company changes. And these are actions that occur, and a lot of times companies don't think about them as affecting their ESOP, and so ESOP attorney or administrator or whoever is handling the amendment of the plan doesn't think to ask the question or amend the plan. So I've come across quite a few in the past plans who were previously C corporation, obviously electing S to take the tax exempt nature of the ESOP S Corp, and the problem is that you can't just make an S election and assume that your document will comply. You need to add the 409P language if it wasn't already there. And for older plans, 409P was generally not part of the original document. So it's not going to be there, and it needs to be something that is added as you make the S election, effective at the same time. Failure to have that language in is a qualification issue subject to disqualification by the IRS. Will that happen? Unlikely, but they will slap you with a penalty to avoid that disqualification. Some good news, some bad news. The IRS has now consistently been asking plans to include, during the determination letter process, they've been asking us to include in the plan document whether and when the company became a C or an S corporation, so that it's clear on the face of the document which provisions apply, because there are provisions within the plan that apply to C's and not S, and vice versa. And another pitfall is with the bylaw amendment. I've come across this as well. I can't say that the IRS has ever caught this on audit. I haven't seen it, but we definitely want to fix it before we have to worry about what the IRS or the Department of Labor will do. And that is a bylaw amendment for C corporations who want to make cash-only distributions. They don't want to make the stock distributions to participants. They only want to make cash distributions. If you are a C corporation, you have to have a bylaw amendment that restricts the ownership of the stock in order to allow for cash-only distributions. S corporations can take advantage of this automatically. They don't need the bylaw amendment. But if you are a C corp, I would check your bylaws to make sure. Sometimes that does get overlooked during a transaction. And lastly, in acquisitions, sometimes not thinking about the effect on the plan. People forget that when you acquire a new company, whether it's a subsidiary or what have you, you need to pay attention to whether those employees should be included in the plan or not. Operational compliance, switching from amending the document for statutory and regulatory changes, switching over to the operational compliance. The key here is use your document as your roadmap. Follow the map. If it's not in the map, you need to change it. You need to see if you can change it, and then you need to make sure you change it before you start operating in non-compliance. So common pitfalls in this area, and they're really all over the map because people don't technically read the document close enough to make sure that the actions are complying with the terms of the document. So a couple of these, distribution timing, for instance. The distribution timing is hard, and there are a lot of different provisions in an ESOP. When I first started practicing, I had to sit down for a couple hours and figure out which distribution provisions trump the other ones, and when the other ones trump. Because there's always going to be at least 3 provisions, I think, for distribution, and they're all kind of kicking in at different times, and some of them don't ever apply, and so it is difficult. So that's why it would be good to have a distribution policy when you do start making your distributions, so you can make the rules clear. Certainly creating a cheat sheet of the plan's terms, including the distributions. When do distributions start for death, disability, retirement, and other terminations? What form do those distributions take? Are we talking about stock or cash distributions? And when we talk about form of distributions, we have to remember that that kind of loops into whether you are recycling or redeeming. You can't just assume that you're going to go through the process just by following the same process every year. If you're doing a redemption of stock, you need to distribute stock. So you got to have certain language within your distribution forms that allow for either the put option, or if you're redeeming directly from the ESOP, you've got to have the simultaneous valuation, which we're going to get into in a minute. But it goes back to really following your roadmap and making sure that your roadmap reflects what you're doing. Some other operational pitfalls, going back to documenting where there's an ambiguity in the plan, documenting the interpretation that's taken on that provision. It's key. If there is a possibility that the DOL or the IRS could interpret one provision in two different ways, and you know that when you're looking at it, it's not a big deal to just do some minutes of the plan administrator and document how you interpreted it, so that you can show that to the IRS, but also so you can follow it in the future and remember. Prohibited allocations under 409P and 409N for S Corps and C Corps. Again, key in making sure that you're operationally complying with the 401A and 409 requirements, and quite honestly, it happens a lot when companies and ESOPs are using administrators that aren't really familiar with the ESOP requirements. They tend to disregard the 409P and N requirements. 409P much more catastrophic to a company for failing to comply with it. 409N, excise taxes involved, but you're not going to lose your F election. So need to be wary of these two provisions and making sure that the plan complies with them. I would focus, 409P. We've probably, if you've listened to a 409P presentation before, it's a scary section and it gets talked about a lot. But if you are an S corporation, you should be making sure that your administrator is doing 409P testing every year. If you have not heard of the 409P testing at all, then you need to bring that up, and you probably need to find a new administrator because that is key for S corporation ESOPs. Another one, definition of compensation. People generally don't pay too close attention to how the plan defines compensation, but again, this is another one of those provisions that can be defined in a lot of different ways. And so you need to make sure that you look at that and you're providing the right data to your record keeper when you're providing them with what is compensation for your employee census. Required minimum distributions, we talked about that really briefly, but this is another common pitfall in that if the administrator is not paying attention, and that does happen, those people who are 70 and a half and have terminated employment, they are required to get a distribution at certain periods. You force them to take this distribution. It's not up to them. It's required by 401A9 of the Internal Revenue Code, and so we have to watch and make sure those people are getting their distributions. And again, this is one of those distribution provisions that trumps all the other ones. It is required no matter what. And the last one I have up here is the diversification elections. Diversification is particular to ESOPs. An administrator who is not familiar with ESOPs is going to miss this, and they're not going to alert you to the fact that you should be making diversification or issuing diversification notices to participants, so you got to be wary of that. Again, if you haven't heard, if you have a plan that's been in place for 10 years, then you need to be thinking about whether you're in compliance with your diversification provision. A quick note on ESOPs and 401K plans, a couple of pitfalls here. Going back to the definition of compensation, I try to make sure that when we're doing a new ESOP, that the definition of compensation in the ESOP and the 401K plan match. Because my hope is that it is easier for a company to provide the same data to their 401K administrator and the ESOP administrator, and in order for that to work, the definition of compensation in both those plans has to match. That does not always happen. So you might want to look to see, does my 401K definition reflect the same required payroll, bonus, whatever included in there as is required under the ESOP. Because some drafters do not pay too close attention to that, and you may be providing the wrong data to one or the other of your, or both of your administrators in determining allocations and testing and all that good stuff. And if you're excluding certain items from compensation, there are safe harbor definitions of compensation. That is, they don't need to be tested. The IRS has blessed them. That's typically what we use. But if you pull something out of the definition of compensation, then every year the administrator needs to run an additional test. So usually that's not the case. That's only kind of once in a while that happens, but you should check on that. What happens with the excess annual additions? So this is your limit on individual allocations each year, the 100% or the lesser of 100% of salary, or I think it's $45,000 now. I lose track of it, but it's that requirement that is called the annual addition. If a participant's allocation exceeds that, then usually we're talking about a 401k and an ESOP being tested together. And the question is, if the participant is exceeding that amount by combining the 401k and the ESOP allocations, what happens? Do you take it out of the ESOP? Do you take it out of the 401k? What happens? And do the plans agree on what happens? Do both of them say the same thing? And now I'm going to jump right into the transactional requirements. So for those of you who have already done a transaction or are looking at doing a transaction, that is having the ESOP acquire company stock, this will be, I think, enlightening for you in terms of giving you some education on details that you can watch out for. So remembering that ESOPs are unique in their ability to first borrow money from disqualified persons, and that most of the sellers that we deal with will fit within the definition of disqualified person. That is usually your officers of the company, your majority, major shareholders of the company. We call that borrowing of money from a disqualified person an exempt loan. That is the ESOP loan. And the purchase of employer securities from a disqualified person is also a unique ability of ESOPs. So in order to engage the ESOP in the borrowing of money from a disqualified person, or to purchase employer securities or company stock from those people, there are additional requirements placed on it. And without meeting those requirements, this is called a prohibited transaction. If an ESOP buys company stock from a disqualified person and does not meet the requirements, the plan has entered into a prohibited transaction, and there are excise taxes to be paid. Unfortunately, I have seen too many exempt loans in the last couple of years in which the loan terms did not meet the exempt loan requirements, and so they are, by definition, prohibited transactions, and the excise taxes, the penalty for that is not a small amount. So I want to help you avoid that. So when you're looking at borrowing between the ESOP and a disqualified person, whether that is a seller who takes back a promissory note, or whether that is the loan between the company and the ESOP, that is by definition an exempt loan, or it is an ESOP loan that hopefully is exempt. Some provisions to pay particular attention to. In a non-ESOP promissory note, these things are all present. That is, proceeds can be applied to the repayment of anything when you're using outside of the ESOP context, a regular note. That is not true in an ESOP promissory note, and there's language that must be included in the note that makes sure that the proceeds can only be used to acquire, that is, the money borrowed by the ESOP can only be used to acquire qualifying employer securities and to repay a loan used previously to buy the qualifying employer securities. The second one is a default results in acceleration of payment of the total balance outstanding. This is in a typical note. If someone doesn't pay on their annual or quarterly or monthly payment, the holder is able to accelerate the balance. In an ESOP note, that is absolutely not true, and probably the most typical problem I see with ESOP notes is that the note actually contains this provision, but an ESOP note is not allowed to accelerate the total balance upon a default. It must be limited. So that language you can look for. A typical note allows recourse against the borrower. ESOP, you can't have recourse against the ESOP. The only collateral allowed in an ESOP note is the qualifying employer securities that are acquired with the particular loan proceeds received on that note, and those used collateral on prior exempt loans repaid with the proceeds. So if I'm issuing a note to the ESOP, if the ESOP, is issuing a note to the company, the only collateral the ESOP can offer to the company is the shares of employer securities purchased with that note. That's obviously not true in a typical promissory note arrangement, and there are no release requirements within a typical note. There are collateral release requirements, that is, shares must be released in accordance with particular formula, which we're going to see in a minute, that is required by regulation. So again, if you don't see this particular release provision in the pledge agreement or in the note or the loan agreement, you've got a problem. The last one is something that the Department of Labor has been picking up on and has been forcing companies to amend, claiming that it makes the note a prohibited transaction. I disagree with that. There's nothing in the law that says this, but that being said, if the DOL just asks you to amend your note and isn't applying any fees or penalties for that amendment, that no harm, no foul. So the DOL will look in the loan documents, the ESOP loan documents, to see if there are any provisions for the payment of costs and expenses, including attorney's fees incurred by the lender in enforcing its rights under the note. And ESOP, according to the Department of Labor, cannot be obligated to pay costs and expenses of collection on that note. So these are ESOP-required provisions. If you see any of these in an ESOP note, you need to amend your note because you have a non-exempt loan that, assuming that note is with a disqualified party, but typically you have a problem, or at least ask a question because you may have a problem. So just a list of the prominent ones that I've seen in terms of the exempt loan pitfalls: language requiring the acceleration of payment in full upon a default. Again, you can't accelerate that payment of the outstanding balance due. Language requiring the payment of legal fees. We see that's a whole lot, and really it's just requiring a change, an amendment to the promissory note or the loan agreement, and so far the IRS has not done anything with the DOL's request on those. And the last one is over-collateralization. So going back to, you can only pledge the shares purchased with that exempt loan. I've seen a number of cases in which, let's say the ESOP was buying the company stock partially with cash in the ESOP and partially with a note. You have to make sure that the cash exchanged for a company stock, that company stock cannot be pledged on the note. It was straight out purchased by the ESOP and is allocated to participants. It cannot be pledged on the note because it was not acquired with the note. So another pitfall to watch out for. This is the annual stock release that I referenced in the table there. There are two different types of release calculations, the principal only release, and then there's the principal and interest. The principal only can only apply to a loan that's 10 years or less. And it's pretty straightforward, but a lot of times a non-ESOP administrator will get this wrong. I've seen that over and over and over again, and this will get picked up on the IRS or a DOL audit quickly. It's very prominent. It doesn't take you long to figure it out. But non-ESOP administrators will release shares based on the fair market value of the shares, and that has nothing to do with it. The shares are released based on the terms of the note and the number of shares in suspense. It has nothing to do with the fair market value of the shares. So you either have the principal only method, in notes that are 10 years or less, or you have the current principal and interest for notes that have a term greater than 10 years, and there are a couple of other requirements. But the key is to make sure that your release is being done correctly, and that is a big one in terms of both operational compliance and making sure that you comply with the terms of the exempt loan. So that was the exempt loan requirements. I'm just going to cover a couple of these quickly as we get down here. We have 10 minutes left. Just to point out that when you're acquiring company stock, when the ESOP is acquiring company stock, you need to make sure that you have this adequate consideration opinion. And the pitfall here is that most often the pitfall is where a company is using a redemption mechanism for distributions. So in order to get cash to a participant who's terminated, the company is cutting the check to the ESOP and taking back the shares from the ESOP. That technically is a prohibited transaction. In order to get around that, you have to make sure that you have a simultaneous valuation. That is, you know that the stock is being acquired or redeemed by the company for adequate consideration. So watch out for that one, because I think a lot of companies don't pay particular attention to that. So the pitfalls here in acquiring employer securities: failure to obtain a valuation as of the exact purchase date, a valuation firm that has to be independent and, of course, knows ESOP valuation, and then back to the point of failure to follow the requirements for the annual redemption of shares for distribution purposes. So sources of pitfalls, as we finish out, we have 2 slides here. Sources of pitfalls is, I got to say, we say it all the time in our voluntary correction submissions, and that is the wrong advisors. It's like hiring a matrimonial attorney for a bankruptcy action, or hiring a corporate attorney to do a litigation matter. Your advisors, from the attorney to the administrator, the trustees, the financial advisors, they should all be ESOP experienced, and there's no replacement for that, because the consequences of these pitfalls can be pretty serious depending on the pitfall. And a lack of correct or communication at all with your advisors. So for instance, the conversion of C to S, no one thinks about amending their plan, but you need to communicate those changes so that the people who know about amending the plan can say to you, if you're making that change, you got to do X, Y, and Z. And how to avoid these pitfalls, or how to find them before the IRS, the DOL does, and then assesses penalties. Obviously, confirm and clarify who is watching your plan's qualification. I don't think anyone, including the IRS, expects a company to be watching the statutory and regulatory changes that happen every year or every other year, but you should at least have someone in place engaged to be watching out, so they can let you know, this year such and such statute changed, we need to amend the plan. Make sure you've read and understand the plan, or somebody has read and understand the plan, so that, again, you can follow your roadmap. Confirm all actions taken are supported by the plan and the trust terms. If you're doing something and you can't find in the plan where it says you can do it, you need to find out why or amend the plan. Going back to the point about the wrong advisors, hire advisors with ESOP expertise, and make sure you're performing due diligence, because we all know there's lots of people out there that say they do it, but they don't actually have the depth of expertise to do it. Review your transaction documents for the presence of the prohibited language. So the little schedule there of the 4 or 5 provisions that ESOP notes should have and should not have, you can review your own transaction documents to see if you have a problem there. And in closing, don't go it alone. Make sure you have good advisors. The plan documents are your most important roadmap, so if it's not on the roadmap, don't do it. Most of the time, legal pitfalls for ESOPs are accidental. The companies don't, and the CFO, the president, whoever is in charge, they don't actually understand, you can't redeem the stock without a simultaneous valuation. The problem is that the consequences for falling in those pitfalls, it's like a landmine sometimes. The consequences are big. So if in doubt, make sure you ask a question and have your documents reviewed. And again, not every professional is an ESOP expert. And I am going to unmute the line and see if anybody has questions. Certainly, you can also...
The conference has been muted.
You can type in your question as well.
The conference has been muted. The conference has been unmuted.
All right, it took me a minute, but I did it. Does anybody have any questions?
That will be the initial shares that are
ESOP trustees subject to first sentencing guidelines.
from the payments, and they'll get allocated to participants' accounts.
Oh, we did get a question. Is the outline today, there's a presentation, the PowerPoint is available, and yes it is. If you email me or Alice, who I think you received an invite from, we would be glad to send you the PowerPoint presentation.
Okay. So if I email this lady here, Alice, ask her for hard copies. Yep. Last time I think she sent it to everybody anyway, so yeah. Right, because everybody's name was on it.
Cheryl didn't like it, and Greg doesn't like it.
Are there any questions? If not, that's fine. I hope everyone learned at least one tidbit. And again, the recording will be available on the website if you feel the need to go back. Have another question here. We have typically relied on our TPA for all compliance and monitoring. Is that typical? I think a lot of companies do that. I would just make sure that the TPA is aware and check your engagement letter with the TPA to make sure that they are aware that you are relying on them. Because if I got to say, if it's not contractually they're agreeing to update you for compliance, they're not going to be liable when the IRS comes in and says you failed to do X, Y, or Z. So you just want to make sure that everybody understands who is expected to update you.
Okay. But that's one of those things, like, I wouldn't, until we know someone else that we like, you wouldn't.
PremiumBeat.com